Good morning, Mr. Unikowski, Mr. Ellison. This is our final case of the morning call. It's Hassan Ahmad versus the University of Michigan. It's a 20-minute oral arguments per side. And Mr. Unikowski, you may begin. If you want to reserve some of your 20 minutes, we leave it to you to try and control that, and wish you the best of luck. You may proceed.
Thank you, Your Honor. Yes, I'll reserve 3 minutes for rebuttal, and I'll watch my time. The Court of Appeals erred in holding that the Tanton papers are public records under FOIA. The statutory definition of a public record, construed in conjunction with the statutory purpose clause, established that the Tanton papers are not public records. They are created by a private citizen, they're merely being stored by the government, and they don't record or otherwise shed light on any government activity. So I'll begin with the statutory text. The statutory definition of a public record is, quote, a writing prepared, owned, used in the possession of, or retained by a public body in the performance of an official function from the time it's created. So as we interpret that phrase, the proponent of disclosure has to show two elements and then a relationship between those two elements. So the first element is the possession of the writing, and we don't dispute that that's adequately pleaded in the complaint. The second is the performance of an official function. And as we interpret this phrase, that's got to be different from the possession alone. Otherwise, the two requirements would blend into one. And in this case, the plaintiff hasn't pleaded that because really all the university is doing is possessing the documents. In other words, it's the storage of the documents is used by plaintiff simultaneously to show both the possession prong of the statute as well as the performance of the official function. And we don't think that the plaintiff can do that. And moreover, the plaintiff also has not adequately pleaded the relevant relationship between the possession of the writing and the performance of the official function. I think to figure out what that relationship is, it's helpful to look at the statutory purpose clause. So the purpose clause recites that it's the public policy of the state that all persons are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them as public officials and public employees. The people shall be informed so that they may be fully participate in the democratic process. So I think that when you read that, it's clear that the relationship between the possession of the writing and the performance of the public function has to be that the writing somehow records or shed light on the public function, because that's why the document would give citizens information regarding the affairs of government and the official acts of those who represent them. In this case, the documents don't do that. They're Mr. Tanton's private records. They're merely being stored by the government. They don't record any government activity. In fact, the complaint itself says that plaintiff wants to use these documents to shed light on federal immigration policy, nothing to do with the university or the functions of the government of Michigan. And so I don't think that the statutory definition is satisfied. I'd like to just also refer the court to a federal case, which is quite on point. We're certainly mindful that federal cases are construing the federal FOIA. They're not binding on this court, but it's substantively, this court has previously considered federal FOIA precedent in interpreting Michigan's FOIA, and we'd urge the court to do the same here. The cause of action case from the DC Circuit is probably the most relevant federal case. It's really directly on point. The question is whether the storage of writings in the National Archives are sufficient to make those documents agency records under the federal FOIA. The DC Circuit said, quote, that they did not, quote, that the archives does not use documents created by the three branches in any operational way, or indeed in any way comparable to any other federal agency. It may control them in a sense, but its control consists in cataloging, storing, and preserving, not unlike a warehouse. And therefore, the court said that, quote, as a matter of statutory interpretation and congressional intent, Congress did not intend to expose legislative branch materials to FOIA simply because the material has been deposited with the archives. And we urge the court to adopt the same construction of a public record in Michigan's FOIA. With that, I'm happy to take questions from the court.
Thank you, counsel. We'll start with Justice Clement.
Thank you. Just one quick question. So are you saying that the Tanton papers will never become public records even once that time limit is up and the library makes them available?
We do think that, although even if the court disagrees with me on that, we could still prevail in this case. So our primary position is that yes, The Tanton papers don't shed light on the affairs of government, whether or not they're exposed to public view. At the time they're exposed to public view in 2035, the question will be somewhat academic. You won't need to file a FOIA request to get the documents. You can just go to the library and look at them. But we do think that they won't satisfy FOIA's definition even at that time. If the court disagrees with me, though, there is a way to interpret FOIA such that they would be public records then, but not now. The argument would be that in 2035, the university is actually displaying the documents. It's not just possessing them in anticipation of displaying them. And so in that scenario, there's a different public function, the display of the documents. Whereas right now, really all it's doing is storing the documents under lock and key, which I don't think is enough. We don't think is enough to satisfy the statutory requirement. But our primary position is that they're never going to be public records.
Thank you.
Justice Kavanaugh.
No questions.
Justice Welch.
No questions.
Justice Zara.
No questions. Actually, the presentation you made resolved the only question that I had. Thank you very much.
Justice Viviano.
Yes, thank you. Counsel, the problem I'm having with your argument is, I mean, starting, I guess, with the federal cases, is that the federal statute is a lot different than our statute in that it doesn't have the agency record. The terms are not defined like they are with our statute.
I'm sorry.
No, I was going to say, so that's given the federal courts some more range, I think, than we have, and they've developed, these various tests and in particular, the idea that control should be required, which seems to make a lot of sense. The problem I have is that our statute doesn't require control. It requires ownership or possession, but it doesn't say control. So what do we do with that?
So I'm certainly mindful of that distinction, and I agree with you that the federal cases are at most persuasive authority. They're not binding. The DC Circuit had
my point is they're not even persuasive though, because they go on to provide a definition for a term that our legislature has done the work of defining in our statute.
Well, in the cause of action case, the DC Circuit was interpreting its own prior precedents, which had construed agency records to encompass, quote, documents that are in the agency's possession in the legitimate conduct of its official duties, which sounds quite a lot like the statutory definition. Now, that was a judicial gloss on the federal statute. It wasn't a statutory definition, so that is a distinction. But the court did interpret precedent that defined agency record quite similarly to the legislature. I also think that it's true that there's a statutory definition, but we think the statutory definition should be interpreted at least in conjunction with the statutory purpose clause, because that's as much part of the statute as the statutory definition of a public record. This court has many times held.
Not quite. I mean, not quite as much, right? We wouldn't look to the purpose to create new substantive rights or obligations, would we?
No, I don't think so. But I think that ambiguities in the definition of a public record can be construed in conjunction with, can be resolved by the purpose clause. In other words, I think it's appropriate.
Do you think the definition of public record is ambiguous?
Well, I think that it favors us, but to the extent that it is ambiguous, the statutory the statutory purpose clause would resolve those ambiguities in our favor. So
the problem you're having is that the library, when you're trying to tie together the use or ownership or possession of the document with the performance of an official function, the problem you have in this case is that this government agency doesn't do anything. I mean, in a sense, with the document, right? They don't make decisions based on it. They don't take certain actions. Their job is to store the document and warehouse it and archive it, right? Isn't that the difficulty you're running into here?
I don't really think it's a difficulty. I think that argument in some ways supports our textual argument. 100% based on the text, not based on the purpose clause, not based on the federal cases. I think that it's counterintuitive to say that the university is possessing the writing in the performance of the possession of the writing. I just think it's textually wrong to say that the possession can simultaneously satisfy two distinct statutory requirements, one to possess the writing and one to engage in the performance of a public function. I think that that's why the possession has to be different from the performance of the public function. And if it is, then the plaintiff hasn't adequately pleaded those elements, because the sole public function that the plaintiff pleads is just the very possession of the writing that the plaintiff is using to satisfy the distinct element possession requirement. So
a skeptic might say that you're really stretching to come up with a way to say that these documents don't fall within our FOIA statute. For some reason, to avoid, we're avoiding what I think is to me should be the essence of this case, which is the discussion of whether the exemptions apply. And I guess I'm a little curious as to why. I don't even understand why we're hearing this case without fully considering whether the exemptions apply, except that it appears maybe that your client decided to bring a C8 motion in the trial court and not turn over a copy of the agreement. First of all, do I understand that procedural history correctly?
I'm not sure that's right. So the plaintiff did not ask for that in discovery in the trial court, didn't ask to delay the proceeding pending discovery. And in fact, the Court of Appeals sought supplemental briefing on this issue. And we made this point to the Court of Appeals that the plaintiff hadn't sought this document in discovery after we filed our motion for summary disposition.
Is that a public document?
No, we don't think it is. So the first question is whether it's a public record under FOIA. It would be a public record under FOIA, although some exemptions to FOIA disclosure probably would apply. Certainly in the context of litigation, that the pending litigation exception to FOIA would apply. Even outside of that, the personal privacy exception to FOIA might apply to the agreement. But I think it would be a public record. It would satisfy that definition because it does shed light on the affairs of government in the sense that the government actually entered into that agreement with Mr. Tanton.
Are you litigating the exemptions, or am I wrong that you've held off on that to this point?
We haven't we've reserved our rights with respect to that. I mean, if the court were to affirm the Court of Appeals, then we'd certainly go back to the trial court and assert exemptions. We'd say it's immune from disclosure under statutes that authorize libraries to accept gifts. We'd argue the privacy exception to FOIA. I mean, we'd make a bunch of other arguments. There's no doubt about that. But we think that this case shouldn't even get there because it doesn't say, just as a matter of law, it's not a public record. And so we disagree with the Court of Appeals decision on that question. Just another point is we're quite reluctant to litigate the personal privacy exception. We'll do it if we have to, but we don't want to have to go through individual documents and explain why the exception is satisfied. We don't think the court should even have to get there because a document prepared by a private citizen that the university is merely storing just shouldn't even be subject to FOIA in the first place. So we would certainly make additional arguments on remand, but that's why we're here.
Would you have to go document by document under that exemption, or couldn't you claim the whole cache of documents based on the agreement?
That certainly would be our argument number one, that the whole cache of documents would be protected. Obviously, there's concern that the trial court might disagree with that and require inspection of the documents. We would certainly forcefully oppose that. We want to just head off even that legal question even coming to light by simply a holding that these documents aren't real.
I get it. I get the litigation strategy. From our standpoint, I'm just not sure we're in the best position to address this case without fully considering all the arguments under the act, but and under the other statute that you referred to. So thank you, counsel.
Counsel, I have a question. Does it matter who the government is? A government agency, the University of Michigan, or is it the Bentley Library? I mean, I don't think of the Bentley Library as a separate government agency from the University of Michigan, and I'm not sure any of this matters. What's your answer to that question, and does it matter?
I don't think it does. I think that the university is the public body. I think our position has been that the library is part of the university. We haven't argued that the Bentley Library or the university isn't a public body. We've never made that argument in this case thus far.
And so what is the official function of the university or the Bentley Library if it doesn't matter? Was the Court of Appeals right to look at their bylaws and say it's storing documents? Is that
I mean, we're not. Of course, the university stores and archives documents, and the library archives documents. That's part of what the university does. We're not saying that they're just storing the documents as a personal favor to someone who needs private storage. Of course, the documents are being stored for purposes of displaying them in the future. But we don't think that satisfies the statutory requirement of the performance of a public function that's distinct from the possession of the documents, nor do we think that there's a relationship between the possession of the documents and the distinct performance of a public function. I just think the best way to read the statute is to require the documents to shed light on something that the university is doing, which they don't in this case. In every other case that we've looked at, that statutory requirement has been easily satisfied. The Amber case, which is from this court, I think has a useful discussion where the court explains that the reason these video surveillance recordings were public records is because they shed light on the government's decision to issue misdemeanor citations. So there you can see that there's clearly a distinct public function, the issuance of misdemeanor citations. And because the videos were actually used operationally by the government to support the decision to issue those citations, there's a relationship between those two things. And here that's just not present. We understand that in some sense, one thing that university libraries do is archive documents for purposes of later displaying them to the public. But the documents don't record, the documents being stored themselves don't record any government activity. So if I can just say one more thing about that, we agree that if there was some university document that memorialized its thinking about when to accept gifts or maybe when to accept this gift, that might be a public record, even though there might be an exception, because it would shed light on the government's decision-making. But that's just logically different from documents themselves, which really are privately created documents.
Thank you, counsel. One additional question. I appreciated the back and forth with Justice Viviano about how to think about the purpose language that conveniently is actually in this statute, right? Usually we do our best to really try and understand just the plain meaning of the words of a statute, because we don't want to overlay our own, guesses about what the purpose was. But here we have purpose in actual legislative words. It's unusual. We don't usually, we don't always have that. And so I heard you to say that you think we only use those when there is some ambiguity about a term in the statute. Is that your whole answer to that question for how we think about those words?
Well, yeah. So I don't think that you can use the purpose clause to just create out of whole cloth an exemption that doesn't exist. I mean, ultimately, the court is bound by the text of the statute, including the definition of a public record. At the same time, FOIA is a very broad and general statute. It applies to lots of agencies that may not have been predicted when the legislature enacted it. And I think that by enacting the statutory purpose clause into the text, I think the legislature was basically directing courts to interpret the text with a little bit of common sense reasoning based on the statutory purpose. And as you said, the court doesn't have to guess to that. So look, the definition of a public record is very broad and very general, and we don't think it's just unambiguously encompasses these documents. And if you perceive any kind of ambiguity, or at least that it's a very general provision that doesn't resolve every case, certainly not this case, then I do think that the purpose clause becomes pertinent.
Thank you. You may reserve the rest of your time.
Yes, thank you.
Mr. Ellison, you may proceed.
Yes, good morning. Philip Ellison appearing on behalf of the appellants this morning. Thank you for the time here today. I'm going to start by pointing to this court's prior decision in El Khalid that said it taught and in fact informed the lower courts to stop erroneously conducting what amounts to a C10 analysis when there's a motion that's been filed under C8. The issue that's the status of this case, to go back to Justice Viviano's question earlier, is this was a pre-answer motion for summary disposition. The only question before the trial court at this time is, had Mr. Ahmad pled sufficiently a FOIA claim? Now, we are a notice pleading state. All that needs to be provided is the nature of the claim that's being litigated in the particular court. The Michigan Court of Appeals has dealt with this back actually in 1983 as to what is the standards required to plead a FOIA case. And it is that you made a FOIA request and that you were denied. And at that point, it becomes the burden of the government to show that that denial was sufficient. Because this was filed under C8, I'm going to take the unusual request, and I did so in my appellee brief, to ask this court to vacate its leave of grant in this particular case and remand this back to the trial court. I accept and I agree with Justice Viviano's inference in his questions in that this may be a premature grant of application at this particular stage, because what the university is attempting to do is trying to argue that that the Court of Appeals determined that this was these were public records, and that's not what they did. On page 5 of their decision, all they concluded was that it was sufficiently pled. And at this point, the university has its full range of defenses, its full range of opportunities to raise exemptions and other details going forward as to why these papers can't be submitted or otherwise ordered disclosed by the FOIA statute. Now, I would point to the court that I think what's really happening here is that the university is attempting to create an exemption that doesn't exist in our law. And I have gone to great lengths, and I'm not going to read my brief, obviously, or reiterate that today. But for example, just in my preparation for this oral argument today, I've easily found 3 states, West Virginia, West Virginia, Georgia, and Tennessee, who all have exemptions under their respective FOIAs or open records law that exempts these kinds of records going forward. Michigan has not. And so this court, I don't think, is in a position to act as a super legislator to actually impose or otherwise create an exemption that the university wants in this particular aspect. I leave it with the point of is that the standard by which the standards and definitions the legislature provided us by the definitions of Section 2I, I think, are clearly been sufficiently pled. All that needs to be shown is that a writing, which in a writing's got basically any way you can track content or record content, is whether that writing is prepared or owned or used or in the possession of or retained by the university as part 1. And I think that's undisputed. In fact, they even concede numerous times throughout their briefing that they're storing the documents. That means they easily retain them, but they also own them and they're also in possession of them. It's the second part that says in the performance of an official function. They are retaining these in the performance of official function. Bentley Library's explicit function is to, and this is the line from the bylaws themselves, collecting, preserving, and making available materials pertaining to the state, its institutions, its social, economic, and intellectual development. It easily fits within being a public record. The tougher question and the question that is trying to be avoided is whether this fits in a exemption. And that's a question that the trial court needs to answer in the first instance. So I would ask this court to affirm the Michigan Court of Appeals decision as being correctly decided that this case has been sufficiently pled and remanded for normal case development. And essentially, what I hate to say it, put us back at the starting point, back in the trial court. I'd be happy to answer any questions the panel may have.
Thank you, Mr. Ellison. Justice Clement.
No questions. Thank you.
Justice Kavanaugh.
No questions.
Justice Welch.
Yes. So Mr. Shimkus, I just have a really quick question.
Mr. Ellison. Yeah.
Sorry.
That's okay. You're new today, so you get the pass today. So
I'm muted a few times. Yeah. Technology. I have just one quick question.
Yeah.
Is it your position that all the books in the library then are subject to FOIA under Michigan law?
Well, no, because the reason being is, would they be, now I want to be clear, we need to parse that thing out into 2 steps because the legislature has divided into 2 steps. Step 1 would be to question whether or not the books are a public record of the university. And the answer would be, yes, they are a public record. Step 2 would be, would those books fall under an exemption? And one of the exemptions that would fall into would be the copyright exemption, for example, which would provide for an ability for a public body to say, we can't give copies of these because the exemption would apply in that for the copyright going forward. And there's trademarks. There's a number of these that are available both in Section 13 and as well as this court in the MCAA case, which I filed an amicus in that case, allows the legislature to pepper these throughout the entirety of the Michigan statute compiled laws. So, so to answer your question, no, it would not, or no, it would not be subject to FOIA because it would be subject to an exemption. Now, the university in that instance, because the copyright provision falls under 13.1, 13.1, that would be discretionary on the part of the university to decide whether they want to invoke that exemption or not. And that would be their choice at that particular time.
Okay, thank you. Nothing more.
Justice Zara.
Questions, thank you.
Justice Viviano.
No questions. Thank you, counsel.
Thank you.
Let me ask you the same question I asked your brother counsel. How do you think we should think about the purpose language that is in this statute, unlike many others? What do we do about it?
I think if you read, I think I'm going to disagree, obviously disagree with my brother counsel and say that I believe that the purpose that language provides or at least tilts in our favor, not their favor in this respect. What I keep hearing the universe, and if you can indulge me for 15 seconds on this, would be the argument I keep hearing is that these documents don't shed light on how Bentley operates, but that's not what the purpose is. The purpose defined there is about how the operations of government, not that particular government. And so one of the things I think that purpose clause provides in this particular case, the reason for seeking these Tanton papers is because Mr. Tanton was part of an organization that petitioned and regularly tried to influence government policy. And as we noted, and I think even one of our briefs that were submitted to you, is that he was one of the most infamous unknown people in the area of immigration law. I think that the idea behind that introductory clause is to give this court some understanding that the purpose is not to be narrowly construed in favor of closure or government, but in fact designed to be a statement of the legislature to say things should be interpreted widely and broadly. And as a result, I think, of that particular preamble, if you will, this court, and as well as the Michigan Court of Appeals, have regularly held that exemptions have to be viewed narrowly and interpreted narrowly when there's an ambiguity in whether an exemption applies or not. So I think what it would provide for this court would be, I don't think it gives us a direct answer, and I do agree with my brother counsel. It doesn't create something out of whole cloth, but it does give us a fair lens by which to view what the intent of the legislature is. And of course, I don't need to tell this court, because you guys have said it, I can't tell you how many times, that the whole purpose of interpreting a statute is to determine the legislature's intent. And I think it can help provide a context for that intent by what the legislature is trying to do in that respect.
So your view is that the official function that papers might shed light on is not about how the University of Michigan or the Bentley Library governs, but about some other part of government. Is that correct? What is the official function that you think the papers shed any light on here?
Well, to be clear, I'm looking at the statutory language, and what my brother counsel has been trying to argue is that and he does it very skillfully and subtly to try to argue that this only applies to the institution from which you are seeking those documents from. And that doesn't say that. It says the role of government, not the role of that particular government or even of state or local government. In this case, these Tanton papers are part of a group called FAIR, and I would point the court to boxes 25 through 15 are described what they are in Appendix 37B and 38B of our submission. And it lays out letters and correspondence and interactions with government officials, with policymakers, at various levels of both state and local government, and not just Michigan, but beyond. So I read, and so what I would argue to you is that the purpose of that FOIA statute is, or excuse me, of the preamble, for example, is to inform this court that if someone like my brother counsel comes in and argues, well, this only applies to the particular agency that exists and for the particular agency by which these records are being stored or being kept at, I could then point to you to the preamble and say, no, that's not what the intent of the legislature is. The intent of the legislature is for government as a whole, so that this court doesn't unnecessarily read or interpret a statute narrowly, especially in a FOIA statute, which is designed to be presumptively open unless and until the government, not the requester, but the government proves its burden that those records should be foreclosed upon and otherwise not disclosed.
Thank you. I believe Justice Kavanaugh has a follow-up, and maybe Justice Clement. Justice Kavanaugh.
Yeah, I do. I just, I wanted to follow up in your response to Justice Welch's question about the books on the library shelf. And your position is, well, they may not be subject to FOIA because of an exemption, but they would be a public record because they are in the possession of the library, and the library, that's their official function, is to possess books, for lack of a better, simplicity. So if that is the case, if we were to agree with you, do we have to do something with or overrule like the Detroit News case in the Court of Appeals that said mere possession is not sufficient to fall within the definition of public record, or our own Amberg case that repeated that very thing, that when we're talking about possession in the course of your official function, that mere possession isn't enough. Do we have to do something with those cases? Do we have to disavow them or overrule them in order to get to that point?
So to answer your question, I have been, of course, as you know, probably, I am one that brings FOIA cases to you on a regular basis to be, I wish you would vacate those, because I think it sends a signal to the trial courts about creating more narrow exemptions than what are supposed to really occur here, and try to read the statute in favor of the government, which it should not. However, for purpose of this case, I don't think you necessarily need to overrule those particular cases, because, and I was trying to think of a good example that I could bring to this court to distinguish between a public record that is at a government versus a record that's at a government but not an official function. And I'll give an example of this. So pretend as a hypothetical, I have a secretary, she comes in, I'm the government now. Secretary comes into the office, she brings her phone bill with her to work to write a check out to pay her phone bill. Her bringing her own personal phone bill to the work does not automatically make her phone bill, even though it's within the confines of the building at the time, would make her phone bill a public record in that respect. So I think what can happen in these instances is that you've got these strange oddball instances, very rare, I think, in most instances, but you could have that example of the secretary bringing her personal phone bill to work to pay her, write a check out of her on her lunch break and to go mail that to pay her phone bill. That would not make it a public record. And so I think you could limit those, very carefully by saying we don't over broadly apply the official function too far, but there are those rare instances like the phone bill of the secretary that would actually provide an exemption in that case.
What about, and following it, I think this is a hypothetical posed by your opposing counsel, is what about like the U.S. Postal Service, that in processing and distributing, receiving, processing, distributing, delivering mail, they are in possession of my letter to, Justice Welch. Is my letter to Justice Welch therefore a public document?
If the Postal Service, now, and mind you, the Postal Service is always the oddball example in government in everything, obviously, because they're not really government and they're not really, but setting that aside, if the Postal Service was operated by the state of Michigan, the letters would arguably be a public record, and hence why the legislature would likely create an exemption. But because the Postal Service unique relationship to the government is not part of state operations, the legislature has never had the need to create such an exemption going forward. So I get the Postal Service, the appeal of the Postal Service analogy. It's a poor analogy, because what you're trying to compare, and the line I can leave you with, and I'm hoping that will somehow be picked up, would be is my brother counsel are trying to compare the FOIA statute, the federal FOIA statute and the state FOIA statute is apples to apples, when it's in fact an apple and a pineapple. They're just not the same kind of fruit, even though the word apple appears in both of their names. It's completely different. And the structure by which they are designed are completely different. And if I'm gonna co-opt your question there to take it one step further, the case that my brother counsel keeps pointing to, and I had it sitting right here out, which is the cause case involving at the federal level, involving the records of the financial group that got pulled into the archive. In that instance, that's not the federal FOIA statute, but the archivist, the Library of Congress archivist statute, and I'm blanking on the name right now, the exact name of it, actually gave the archivist the ability to withhold documents pursuant to an agreement with the particular federal agency where those agency records came from. And it's cited in a footnote in that particular decision. Michigan has not given that authority to public bodies. So again, I go back to the idea here is I know where it's, we say, hey, there's the word apple and there's the word apple and pineapple. It must be the same case, when in fact, they're not even close to each other and they're not even in the same realm of the same type of fruit. And so I would, if I could leave this court with, in response to your question, would be is, don't get sucked in by the temptation to see apple and apple and reach the same conclusion, because the underlying law that describes these fruits are completely different.
Justice Clement.
Thank you. So I just want to follow up on the conversation that you had with the Chief Justice about these specific papers and the official function that they shed light on are the general role of government, and it doesn't have to specifically be the role of the University of Michigan or the Bentley Library. And then you gave, in follow-up to Justice Kavanaugh, a response or an illustration about a secretary to a public body bringing their phone bill in.
Correct.
So I want to take what I'm seeing and I'm trying to figure out how to apply both of those assertions by you, and let's look at someone different than Dr. Tanton. Let's look at Julia Child. She has contracted with the Bentley Library. She's got a number of documents that clearly don't pertain to government in any way. Some of which she says, "Hey, these have been in my books that have been published. Everybody has these recipes, but I've got a bunch of recipes and stories behind them, and where I got them from, and the dinner parties, and the maybe even political figures that were at those dinner parties where I made them, and I want that to be private for a period of time." So are those documents public records under the example that you gave, or the explanation you gave of the official function and the role of government, and how do we make sense of that?
So to answer your question is that, again, putting in the proper context of what I was trying to answer before is what do we view the preamble or the initial part of the statute to mean, and how does it assist? And of course, my answer is to give some intent, or just give some insight as to the intent of the legislature. What my brother counsel has been trying to do is to say that acts as a leash on how far this court can go in determining what the actual intent of the legislature, and you can only read the statute directly in the confines of that particular aspect. And I just disagree with that. I think it provides more of a context as opposed to a leash. Now, to answer your question about Julia Childs, for example, there are methods and methodologies by which someone like Julia Childs could donate their papers to the library with restrictions. And the easiest one would be for the Michigan University to go back to the legislature and ask for the Julia Childs exemption going forward. Create this exemption so that it can recognize this. This case has been pending for 3 years, and the legislature, despite having, for example, the Emily controversy, which I cite in my brief, the legislature knows how to change the law to support this, and they just haven't here. And they still haven't, and it's been silent on this respect. Now, in addition, and if I may finish I'd see my time's up, if I may finish my thought on that.
Go ahead.
To answer your question is that if Julia Childs wanted to give her papers ultimately to a public body, for example, she could establish a trust that says these papers will be delivered to this university on, much like Mr. Tanton, April 6th, 2035, which they become public records. It's simply what the problem here is, and I point to this out in my appellee brief. All of the arguments of my brother counsel about the policy reasons why we might need to have an exemption for a donor are good ones. They're good ones. There might be a really good, and in fact, the amicus brings up a number of good arguments about why we should respect these. The problem is this court can't create that exception. The legislature has to. Legislatures in other states have done so. The legislature in our state has not, and this court can't create one, even if we really, really want the papers of Julia Childs.
Thank you, counsel. Are there any additional questions for Mr. Ellison? Okay, Mr. Unikowski, you have a couple of minutes of rebuttal.
Thank you, Your Honor. So just a couple of short points. First of all, I think it's clear from the remarks of the plaintiff's counsel that under the plaintiff's position, if it prevails, virtually every single document that the government happens to be holding onto will be a public record, other than very unusual situations where a private employee surreptitiously bring some private document to a government building. Other than those situations, essentially anything that the government holds onto that's a writing will transform into a public record. So I think the plaintiff counsel effectively conceded that all books, all writings, all maps, everything in the university library system is a public record. Not only that, anytime a prison is holding on to prisoner mail, that's probably a public record too, because it's in the possession of a public body and prisons hold on to mail. Anytime a school holds on to student work or stores it in the building, that's also a public record. And I just don't think that's what the legislature intended when it enacted the FOIA. And we're not trying to inject a judge-made policy exception into the text. Instead, we're simply construing the text that separately requires both the possession of a writing and that the possession be in the performance of an official function. And I think that plaintiff effectively conceded that his interpretation would reduce that second statutory element to virtually nothing. I'd also like to make a comment about the purpose clause. Counsel argued that the purpose clause applies to any documents that shed light on the activities of any government, including the federal government's immigration policy. I don't think that's right. I think that the government in the purpose clause is referring to the government of Michigan. This is a statute enacted by the Michigan legislature directing branches of Michigan government to disclose documents in the performance of the official functions of those branches of government. And I think that the correct reading of the purpose clause is that the document has to shed light on the affairs of Michigan government, because that's why the legislature of Michigan is directing Michigan government agencies to turn over public records that they are storing. I don't think the legislature intended to require disclosure of documents created by a private citizen that may be pertinent to the federal government's immigration policy merely because they happen to be stored by a portion of the Michigan government. And I guess the last point I'd make is about the argument that our position is premature. I don't think it is. We're taking a fairly conventional position that accepting all the allegations in the complaint as true, the plaintiff has not stated a claim as a matter of law because the allegations themselves establish that the definition of a public record isn't satisfied. But in the complaint itself, the plaintiff alleges at paragraph 11, plaintiff was aware that his request sought records marked closed for 25 years from the date of accession, but had submitted in the FOIA that the records still qualified as public records. And the plaintiff also alleges, of course, that they were donated by Mr. Tanton. So we're saying that those are the facts sufficient to establish that these documents aren't public records. And in fact, plaintiff sought and obtained a holding from the Court of Appeals that they were public records. The Court of Appeals said, look, the documents are being held by the university, and therefore that's enough to make them public records. And having sought and obtained that holding, I think that it's appropriate for us to seek review from this court to hold that based on the facts as alleged in the complaint that they're not. And I just don't think any additional discovery will shed light on our core argument, which is that the fact that a plaintiff or the fact that a private citizen creates a document and donates it to a university, which is merely storing them, which are the allegations in the complaint itself, is insufficient to satisfy the definition of a public record. Maybe if the case gets to this, maybe if there's questions of whether a FOIA exemption applies, maybe then discovery might be appropriate. But at this stage, I think our argument appropriately rests on the allegations in the complaint.
Thank you, Mr. Unikowski. Let me just see if anyone has any final questions as you are out of time, but I want to make sure if anyone has a question, they have an opportunity. Does anyone have any additional questions for Mr. Unikowski? Okay, hearing none. Thank you both for your presentations. This case will be submitted.